Good morning, everybody. Welcome to another series of oral arguments before the 5th District Court of Appeal. I'm Judge Jim Edwards. Joining me are Judge Evander and Judge Harris. We've got one case on our 11 o'clock docket, and that's Wynn versus Wynn. Each side will have 20 minutes to argue their case. Appellant, you have rebuttal time. Typically, we grant 5 minutes. If you want something other than that, please let us know. If you have something that might make noise, at least turn it down or put it on vibrate. I don't encourage people to turn their phones all the way off because in case somehow we lose you on the video feed, you can always call back in. So without further ado, Counsel for Appellant, you may proceed.
May it please the court. Good morning. My name is Jason Breslin. On behalf of the appellant, I would like to reserve 5 minutes for rebuttal argument. May it please the court. We are here today on an issue of subject matter jurisdiction within the county court of Orange County, Florida. In this case, Mr. Nguyen, the appellant, originally filed an eviction action pro se. There was a response filed by the appellant in this case, pro se, indicating that she had vacated the premises and there was no reason to evict her.
Counsel, I think you can assume we're very familiar with the facts. If you want to move into your argument, if there's something specific, that's fine, but we're all very familiar with the facts.
Okay, absolutely, Your Honor. And the point I'm trying to raise here is that Mr. Nguyen actually lost his property here today in this case. And I think really the ultimate issue that's going to be before the court today is does the appellate court have jurisdiction to hear this? In fact, the underlying subject matter jurisdiction, at least within the appellant's brief, it doesn't allege that the underlying county court had jurisdiction over this matter. We would assert that it's not even a close call based on the amount, based on title of property, and the various other things that were discussed in our brief. Now,
Counsel, it's your position that if that issue had been timely brought to the attention of the trial court and it ruled against you, that would have been error by the county court, correct?
Yes, sir.
And your position is that if that had been taken in a timely fashion to the 5th District Court of Appeal and presented to this court, properly preserved, that you would certainly have won that issue on the subject matter jurisdiction. Is that correct?
Yes, sir.
All right. You had the opportunity following, and when I say you, your firm, Mr. Nguyen, had the opportunity following the issuance of the January 2020 amended final judgment to take an appeal. I think that was rendered January 14, 2020. And your firm filed a notice of appearance January 17, 2020. Is that correct?
Correct, Your Honor.
And you could have raised the issue by taking an appeal of that amended final judgment back in January or early February of 2020. Is that correct?
Correct, Your Honor. The subject matter jurisdiction, it can be raised at any time. It can be raised for the first time on appeal. So right after the judgment, as soon as we were retained, that is one way to go about it.
Right. Instead, you filed a motion to vacate that, and that was ultimately heard, following which there were written final closing arguments presented, and the county court judge ultimately in June of 2021, is that correct, entered an order denying your first motion to vacate, correct?
Yes, Your Honor.
All right, and in the first motion to vacate, you did discuss subject matter jurisdiction. At the hearing orally and in your motion, perhaps, more along the lines of the case should have been transferred to circuit court, correct?
Correct. I think it was more detailed than that, but yes, it was raised as a meritorious defense trying to set aside the default.
But in the written closing arguments, you specifically asserted that the judgments that had been entered were or might be void due to lack of subject matter jurisdiction. Is that correct?
Yes, sir.
And from that order denying that, the first motion to vacate, when was that order rendered?
There was a delay in the original rendition of that. Judge.
Let me do it this way to make it perhaps a little bit simpler. Did y'all move for rehearing or take an appeal from that order within the time frame?
No, we did not.
Right. So we're here really on your appeal from the denial of your second motion to vacate, correct?
Yes, Judge.
Okay, so go ahead and proceed.
So on our second motion to vacate, and you can, and there's nothing prohibitive as long as there's a distinct issue that hasn't been adjudicated, brought up in a subsequent motion to vacate. In this case, while it was raised at a meritorious defense, one, even the appellee argued at the trial court level that the court wouldn't get to subject matter jurisdiction or any of the meritorious defenses unless they found excusable neglect and due diligence on the part of Mr. Nguyen. The court, while it heard the argument, it absolutely did not adjudicate the issue of subject matter jurisdiction. It didn't address it in there, and even Judge Laurent, in her statement on the second at oral argument on the second motion, said, while I considered it, I didn't adjudicate it. So while subject matter jurisdiction can be raised at any time, even at the appellate court can do it sua sponte. Anybody, it can't be waived. Now, there are multiple paths that could have been done on this case, but it's our assertion that by not filing an immediate appeal on the first motion to vacate, that's why we're not here arguing whether or not there was due diligence, whether or not there was the issues that were adjudicated under the first order, because the court said that there was no excusable neglect and no due diligence. And I would acknowledge that by not appealing the first motion to vacate, we waived that argument specifically. But it was never waived on subject matter jurisdiction. One, you can't waive subject matter jurisdiction. And two, in this particular case, the court specifically made no oral pronouncement on the record of their ruling, and in fact took the next step and specifically listed the reasons why she denied the motion, and she only listed due diligence and excusable neglect as the reasons for denying it. Subject matter jurisdiction had not been decided at that point.
Was it brought to the trial judge's attention at the first motion hearing, whether by the motion or whether by the oral argument or whether by the written closing, that there was an issue on subject matter jurisdiction?
Yes, Judge Evander, it was brought up. It was used as as one of the meritorious defenses amongst others to get past that. However, the court never ruled on it. They considered it, but there was never a ruling, and it's very specific in the actual order that was issued by the court that they did not rule on that issue.
What case do you rely on that you can have the successive 1.540 motions if there is no explicit ruling on that one issue?
Yes, Judge. I apologize. I'm not used to arguing from my desk. I'm used to arguing at the podium. It is the Bailey case, Your Honor.
Right, and Bailey, on the first motion, the first DCA found that although the topic perhaps of subject matter jurisdiction had been raised, the identical issue had not been raised in the first and second motions, correct?
Correct.
And it also found that there hadn't even been a hearing regarding the first motion, correct?
correct.
Okay, so that does make it a bit different from what we have here.
It makes it, we would argue that it makes it a little bit different, but it also makes it, our case, more compelling. In that case, the court had to assume that because there was no hearing, there was no transcript on the order, that subject matter jurisdiction wasn't decided. Where here, we actually have the court saying on the record and by the plain language of the order that it was not adjudicated. It was not decided by the court, this issue. So
is that why you have the remedy to seek rehearing if an issue that's been argued wasn't included in the order?
that is one option, Your Honor, but pursuant to the guidance in the Bailey case, you can do it this way also. You can file a successive motion on the distinct issue. Now, again, while we raised the issue as a meritorious defense, we did not ask the court to rule on subject matter jurisdiction at that time. It was the bar, the initial bar that you have to get past when you try to set aside a default, that you have a meritorious defense, so you're not just going in there and wasting the court's time. We raised that, and we also raised other grounds on there, including the statute of frauds as a meritorious defense. And that's where we get to on the other one. It wasn't adjudicated. And when it was timely adjudicated, we would argue that the successive Rule 1.40 motion did raise that issue again. And now the court decided it. And that's when we get to this court here on this appeal.
Mr. Breslin, let me ask you this. On the first motion, you would be fair to say that if you wouldn't even have to go into excusable neglect and meritorious defense, because you could have just raised subject matter jurisdiction, and excusable neglect would not have mattered if the county court had no subject matter jurisdiction. Is that correct?
Yes, sir.
Okay.
Subject matter jurisdiction as a meritorious defense, it arguably can be argued first, that if the court doesn't have subject matter jurisdiction, they don't even need to get to those. However, they went the other way where they decided those two issues first. But again, this was not done. And then we have the judicial order on the sale and the final sale, which is also on this appeal, but we don't even need to get to any of that. Once you have a void judgment and you have a void order, it's void and it doesn't exist. We go back to the point prior to that order being issued. And in this case, you would have to reverse the sale of the house.
Let me ask you this, Mr. Breslin. If we were to rule against you, could you, without finding res judicata, took priority over lack of subject matter jurisdiction, could you challenge the judgment 3 years later? I hope you had a different trial judge and different appellate panel. Making the same argument that the judgment's void.
Yeah, had we now that we're here, once this court issues a ruling, and if we don't take it up another level to the Florida Supreme Court, we couldn't raise the same issue again. Then we would be barred by it, because at this point, not only the trial court has ruled on it, but the appellate, we've exhausted our remedies. But there are cases you can, had we not even entered an appearance 3 years from now, had we not raised this issue, had we not had it adjudicated, we could have brought this up 3 years from now and reverse the sale at that point. It can be raised at any time. And there's a reason why we put certain from public policy and legislative purpose, why we put certain cause of action in certain courts. And you can see by this case that procedurally, this isn't something that the county court normally deals with. And there was a lot of errors that we addressed in our motion and in the record on why those things happen. So
Can you tell us specifically how your client was harmed by any of the technical errors, if you will, the notice of sale going out before the order was entered, the late filing of the notice of publication, and so forth?
Other than losing his he lost his real property, Your Honor. I mean, that's the obvious harm. He lost it.
You're about down to your 5 minutes. Do you want to save the rest for rebuttal, or?
Yes, Your Honor, that would be acceptable with the court.
It's your time. Just let me know how you want to use it.
Thank you. I'll reserve the remainder of my time, Your Honor.
All right. Ms. Kennedy Davis.
Good morning, Your Honors. May it please the court. I am Lon Kennedy Davis, representing Ms. Wynn, who is the appellee in this case. First, I think it's important to note that this court has already denied appellant's emergency motion to stay the writ of possession of property issued to the third-party purchaser. This court's order was entered on May 10th, 2021. This court is also important to note, which you've already raised, that they did not, they decided not to, they did not appeal the final judgment. The amended.
Ms. Kennedy Davis, let me ask you something.
Yes, sure.
I thought the appellee's brief, certainly understood the argument about res judicata controls, but I want to go to the underlying question because it's not in the answer brief, and I understand why, probably. But is it your position as you sit here today that the county court did have subject matter jurisdiction to enter the judgment it did?
Yes, Your Honor, because this was primarily a eviction action. Mr. Nguyen filed an eviction action, and my client, Ms. Nguyen, countered with wanting to, it was her position that it was her house, she paid for it. So they were both taking the position, it's my place, and I wanted to evict the other. So the county court has jurisdiction over an eviction action.
Right, but that doesn't mean it has jurisdiction over the counterclaim that exceeds its limits. The rule 1.170J is pretty clear on it. It says that the demand of any counterclaim exceeds the jurisdiction of the court in which the action is pending. The action must be transferred immediately. Burden is even put on the judge, on the court. I mean, this case should have been transferred immediately.
Yes, Your Honor, we did initially, that was our intention to do so. Well, first, I do want to address that the 5th TCA in the cooperative de seguros multiple centron case, it does state that if there was proper jurisdiction in the county court, and if it turns out to be that the final monetary amount exceeds, it goes outside of the jurisdiction, that it's still proper. It's an order that is not void. It is true, we did consider, we were planning on, we were planning on removing it, Your Honor. But in sitting down with the counterclaim with our client said that the uniqueness of the facts of this case is that the parties were engaged. They were living together for 5 years. They had an agreement. She was paying $900 a month.
But that doesn't change the subject matter jurisdiction. There was a claim for $41,000 on the counterclaim. The court had jurisdiction up to $25,000. Both under the statute, which sets the county court jurisdiction, it didn't have jurisdiction. Under the rules of civil procedure, the trial court was required to immediately transfer it. And, and here's my other concern is, when I was thinking, how could this happen? And I looked at the record, the transcript of the hearing, and you argued to the trial court that, and you cited to the case of Gordon versus Goodrich, and you put it in your written closing as well. As long as the original claim was proper in county court, the counterclaim may remain in that court, even if it exceeds the jurisdictional amount. And you cited to this fourth I don't know if it's third or fourth DCA case, but that case doesn't say that at all. It's not even a county court case. And that concerns me, whether the trial judge was misled into error here.
Your Honor, like I said, as you can see in our case, we did initially plan on removing it. The client wanted to focus on the eviction action to defend and to assert her position. They were trying to evict the other. So we believe that the county court has proper jurisdiction in the eviction action. And based on talking to our client, that's what she wanted to do. But Your Honor, I'd also like to point out that while if they appealed it timely, Your Honor certainly could have reversed the order, as it's voidable, not void.
Ms. Kennedy Davis, you seem to have avoided Judge Evander's question. Did you misrepresent the holding in the Gordon case to the trial court?
No, Your Honor, that was my reading of it. That was my belief.
You agree it wasn't a county court case?
No, we think it was it belongs properly to county court because.
No, I mean, the case you cited was not a county court case. Would you agree with that?
Yeah.
The case of Gordon versus Goodrich was not an appeal from the county court. Would you agree with that?
Your Honor, to be honest with you, I haven't looked at that. Someone else was handling this appeal in my firm.
There's an appeal from the circuit court
Yes.
decision.
Yes, when I wrote that, that was my genuine belief that that's the way that is handled. That's how I read it. Our main position is that it was they're arguing over eviction. He filed it in that court. That's what she wanted to do, is to stay in that court and just argue over eviction. And that's
Wasn't he required to file in county court? I mean, he didn't have a choice on that, right?
I don't know what, that was his choice. He chose county court.
Right, but did he have a choice? Or was he required to file in county court?
Based upon his position, all he wanted to do was to evict her, yes.
If all your client wanted to do was to fight the eviction, no counterclaim needed to be filed, did it?
I understand. Our client wanted to be able to explain the reason why she felt that she owned the property. They were living together, they were engaged.
I understand. I understand the facts. I may not understand them to the detail that you're aware of them, but again, even in her counterclaim, she said she sought recovery damages in excess of $15,000, which at the time, that was like saying we seek damages in excess of the county court's jurisdiction, correct?
Yes, that was our understanding when we prepared that. We sat down with her and
Not what I don't mean to be rude, but what her wishes and demands and suggestions do not change the monetary jurisdictional limits of the court, do they?
No, we like, as we said, as you can see in our claims, we planned on bringing it to circuit court. But in sitting with her, she felt that it might be below 15,000. She explained to us that, again, they were engaged, living together. She said that.
But you asked for damages that exceed the 15,000. So then once you got a default, then you proceeded to quickly get your judgment, whether it exceeded the 15 or not.
Yes, Your Honor. We didn't expect that it was going to go to default since it was a counterclaim. We thought based upon sitting down with her, like we said, that what we intended to do, as you can see in the pleading, but after sitting down with her, she felt that he was going to claim certain offsets because in their own conversations, he was told her he would charge interest. So therefore that was gonna remove it. I mean, significantly lower down the principal amount, that he was also going to claim that he made repairs, they lived together for 5 years, he paid taxes. So she believed that it was going to be, that he was going to make arguments and it was going to be lower. I mean, I don't disagree, like we said, that we did prepare the document intending to remove it to circuit court. But it's with the client gave us a different position, saying, this is all I want to do.
Well, as Judge Edwards just said, the clients, it doesn't really matter what the client's position was. Several, it looks like a few different county judges have touched this case at some point. Has any judge in this case ever said that the county court did in fact have subject matter jurisdiction in this case? Has
Yes,
there been an adjudication on that issue?
yes, Your Honor, in the record.
Which judge and which date?
Yes, in Judge Lorent's order, she said that, I could point you to the record. At the record at pages 334 to 336, there was an exchange in the June 15, 2020 hearing in which the trial court discussed the basis of her ruling. And the court said, at that hearing, that last hearing that we had to vacate, the issue of whether there was subject matter jurisdiction was raised. It was just raised in passing. It was raised in detail during the hearing, in closing arguments, and it was raised by both parties. She said, so although it was not adjudicated in the order, it was discussed by the parties.
Okay, so hang on right there. It was not adjudicated in the order, right? Has it ever been adjudicated in any order that the court had jurisdiction?
Well, she continues, it was discussed by the parties and it was considered by her, and it was not grounds for going back on the order. The reason why I denied it was because you moved under vacating for excusable neglect, but I found there was none, but you discussed subject matter jurisdiction. That could have, I agree, you know, she says, I agree with Ms. Kennedy Davis that you still would have been able to appeal, because you can always appeal at any time subject matter jurisdiction. And that would have been something that you could have raised on appeal. And then,
Counsel, let me ask you to do this. Let me ask you to assume that the county court did not have monetary jurisdiction over your client's counterclaim, did not have monetary jurisdiction to enter the final judgment or amended final judgment. If you make those two assumptions, how do you still win?
because the Florida Supreme Court says at any time is not forever, as they contend. The Florida Supreme Court says that there must be finality. In the Austin Tupper trucking case, the Florida Supreme Court said that there must be some finality to all issues. It stated that the doctrine of decisional finality provides, quote, that there must be a terminal point in every proceeding, both administrative and judicial, at which the parties and the public may rely on a decision as being final and dispositive of the rights and issues therein.
And at what point do you say that it became final here for purposes of that case?
I would say after the the order on the first motion to set aside. If I may continue with addressing the Florida Supreme Court's comments on finality and jurisdiction, Your Honor. In the Florida Power Corp case, the Florida Supreme Court says the trial court's unappealed ruling regarding its jurisdiction to entertain the controversy, even if erroneous, operates as a bar to a subsequent determination of that jurisdiction over that same claim. And this rule applies to challenges to jurisdiction that were actually raised and determined or could have been raised. And actually the Bailey case that they cited adopts that position. And so, Your Honor, they failed on both fronts here. According to Judge Laurent, she considered it and she weighed it in her decision. And so.
Are you saying considering the issue is the same as ruling on the issue?
Well,
They can't appeal a consideration.
That was Judge Laurent's position, and I could point you to a little further.
I've read what she said, but
Right.
how do they appeal the consideration?
She said that she considered it, it was raised in the motions, it was in pleadings, it was raised at the hearing, it was raised in the written briefs that both parties filed. And so
I understand it was raised, so she should have ruled on it, right?
She said she considered it in her ruling. And
She
so
didn't say that as by the time the June 15th order was issued, she hadn't yet said that, had she? That was said in response to the second motion?
she denied it on res judicata. She said her position was that she's saying she heard the same thing and she determined the same thing.
Right, but you keep quoting to us her discussion. Wasn't that a discussion that took place as part of the consideration of the second motion to vacate?
But it was litigated, argued.
Yes, ma'am, yes or no?
Yes, Your Honor.
Okay, so as of June 15, 2020, she had not ruled on it. There was no mention of that in her order denying the first motion to vacate, correct?
According to her, she did, but that's why she ruled that she denied it for res judicata.
Ma'am, in the order, June 15, 2020, is there any mention anywhere in there about the subject matter jurisdiction?
No, not on the face of the order. But she said she considered it, and the reason why she didn't raise it was in the order was because they moved under excusable neglect. So she addressed it.
And again, back to Judge Harris's question, is there an order entered in this case where any county court judge says the county court had jurisdiction over the counterclaim? Not a discussion in a hearing, not anything else. Is there an order that actually says the county court had jurisdiction?
The order on the second motion to vacate states that it was denied for res judicata because I had previously ordered it. So I was in the second order.
Davis, let me ask you this. If the appellant had filed two separate motions, one sought to set it aside as excusable neglect and they had a meritorious defense, et cetera, and they filed a separate motion saying you lack subject matter jurisdiction, seeking to set it aside, and the trial judge only ruled on the first one, would they be required to appeal within 30 days of the ruling on the first one?
It depends. If there was no mention, if they were truly two segregated motions with no mention of jurisdiction in the one for excusable neglect, then I would say no. But if the body of the motion and the hearings and the closings was argued, discussed, and asked the court to consider it for that reason, then I would say yes.
All right. So how about if the motion said, it was one motion instead of two, and ground one was excusable neglect and ground two was lack of subject matter jurisdiction, and the trial judge ruled there was no, enter an order saying there was no excusable neglect, period. Is that something that the appellant would have to appeal within 30 days on the subject matter jurisdiction issue?
I would say yes, because it closes the issue. There was an order entered, and the appellant could have raised there that the court failed to address it in that order because they moved on 2 points and she only addressed one in her order. But I believe that he would have had to appeal that order to raise.
Thank you.
If you have any more argument, you can continue, or if that's it.
Yeah, just lastly, that according to the Florida Supreme Court, there is a deadline, and it was either even on the second front. Keep your honor, keep in mind that on this, it says that it could have been raised, and if let's say we take their position that it was not raised, according to Florida Supreme Court decisions that I cited, it says the time to appeal it, they have to have raised it. So if we hold them to their arguments that they made in their initial brief, that they have not raised it yet, that according to the cases that I cited to you, says that it is barred if it was raised and determined or could have been raised and they failed to raise it. So according to them, it could have been raised and they failed to raise it. And so
Again, you would typically appeal an adverse ruling. Have they had an adverse ruling on the issue of subject matter jurisdiction?
it is our position and our understanding, yes.
Your position is there is an implied adverse ruling.
Not applied based upon what Judge Laurent stated. And we cited to your honors in the record. She said she did. And she said, I didn't put it in my order because you didn't move under that ground. And I was addressing the ground to which you moved under. And they have, according to the Florida Supreme Court.
Well, she did that because you argued at the May 13th hearing that she can't consider the subject matter jurisdiction. You objected when your opposing counsel tried to raise that argument at the May 13th hearing and said, Judge, you can only consider the meritorious defense or excusable neglect. You sort of led the judge down that path, didn't you?
Well, it's my belief that they should have appealed the amended final judgment. And they missed that deadline to appeal the amended final judgment. It's the same position we're taking today, is that there is finality to appeal based upon the Florida Supreme Court says that there is finality. It does not run forever. Every case has finality. Every issue has its finality, and that the public and needs that. That's in the Austin Tucker trucking case. So it was our position at that day that they should have appealed, they let that deadline run. They should have appealed the final judgment, the amended final judgment.
But even if they had not appealed the amended final judgment, they could have raised the lack of subject matter jurisdiction later in a 1.540 motion, correct?
We relied on these cases. We relied on the cases that I just cited to you, yeah, they could have raised it in their motion, their first motion to vacate, yes. But we believe that there is finality, and when they say at any time, it does not mean forever.
I think your time's expired. Unless
Thank
any of
you.
the panelists have other questions, we'll go back to Mr. Breslin. Right. Mr. Breslin. And you're still muted, Mr. Breslin.
My apologies.
No problem.
The issue with one of the issues with Appellee's argument is that the second order was based on res judicata, meaning that literally translates to English as a matter judged. Now, Judge Laurent even says, I did not adjudicate it. So how would res judicata apply? In contrary, they're saying that in the first motion, we could have raised it, but we didn't. But how could you have something adjudicated by the judge or even considered by the court if it wasn't raised? The issue was raised. The court just never adjudicated the issue.
Let me ask you this. In the first hearing, when opposing counsel objected to you raising subject matter jurisdiction, did the trial judge make any type of ruling on that?
No, and the argument, as I recall it, Your Honor, went into the fact that we were raising it as a meritorious defense. And then there's further argument that goes into that where appellate counsel argues that we don't get to those issues until the court gets past excusable neglect and due diligence. Now, it was brought up to the court was aware that it was an issue. And when we talk about finality, this is, I mean, on the amended final judgment, it was not, we're not talking years after this went in and prior to the judicial sale. Mr. Wynn's trial counsel was raising this issue, was pounding the table, filing motions. Did trial counsel go about it the most efficient way? Absolutely. We're not going to argue that.
Yeah, would you agree that there's really no good reason for there having been a clear subject matter jurisdiction argument in the first motion of vacate? And I can't, I'm trying to figure out a good reason not to put that in there.
It was raised as a meritorious defense. I'm not going to try to get in the mind of trial counsel, but the issue she raised was to set aside the default, which clearly has those three categories: excusable neglect, due diligence, and meritorious defense. It was brought to the court's attention, the meritorious defenses. Subject matter jurisdiction was, along with other non-jurisdictional issues with the final judgment as the meritorious defenses. But as we see in the Bailey case, it is extremely similar in that they brought the successive motions. They appealed off the second motion, And here, and there had to be an assumption made that the court wasn't satisfied that a final judgment was made regarding subject matter jurisdiction. Here, we know for sure, Judge Laurent says it, I did not adjudicate that issue. I considered it, but that's not an adjudication.
Counsel Bailey says that the issue in the first hearing was not litigated, not whether it was adjudicated or not, but not litigated. And there was not even a first hearing in the Bailey case. So, you know, the issues, if all y'all had done was raise the issues as you did orally or in your first motion and not included the specific identical subject matter jurisdiction argument in your closing argument, you might have more of a leg to stand on. But as Ms. Kennedy Davis says in that Supreme Court case, it says whether it was raised or could have been raised. And when they deny your motion and part of the motion was subject matter jurisdiction, doesn't that in effect act as an adjudication on that argument?
I would disagree with that, Your Honor. In this case, the judge made specific findings in her order. That this wasn't, I deny carte blanche counter defendants motion. She very specifically says, I deny it on these grounds. And she listed 2 of the 3 grounds that were raised. She didn't even address the subject matter jurisdiction issue, Your Honor.
Right. Well, thank you, counsel. Your time has expired and we will be in recess.
Thank you.